Lawyers. I've got Matt Kollrepp with me. He's the Associate Director in the Litigation Department. Quite often in litigation, Matt, we're either throwing good money to try and recover bad money or throwing good money to stop paying bad money. And it's a pretty vicious cycle, and there's quite a lot of common misconceptions out there that you're automatically entitled to get your costs if it goes to court.
Yeah, that's right, which is not really right. So the first rule kind of is that costs generally at the discretion of the court. So the court decides whether it's appropriate or not to order costs. But there's a rule in the UCPR that says that costs will follow the event. So if you're successful with your claim, generally that means that you'll get your costs back. But ultimately, it's up to the court. The judge will make a decision about it, and subject to an appeal, that's pretty much the end of it. So,
and it's really important the way you conduct yourself in the proceedings, isn't it? Because,
that's right.
you know, if you were to do something that was to hold somebody up or cause them to incur more legal costs, you're more at risk of having a cost order made against you.
That's right. So generally costs, as we said, are at the discretion of the court. Doing things improperly or bringing a vexatious claim or something like that might expose you to what's called an indemnity costs order. And that's where the court basically will award costs, all the costs against the other party. So that's quite a rare set of circumstances. And the other way to invoke sort of the indemnity cost provisions would be to make an offer and for that not to be accepted and sort of to get to a judgment and that to be found to be on better terms than the offer. Then the court can make an order effectively that's that costs be paid from that date onwards all up to trial on the indemnity basis. And that's pretty sort of rare circumstances, but yeah, it's sensible to consider when to make an offer and on what terms. And so
strategy is important.
Absolutely. So talking to your lawyer at the outset, asking the questions about costs, trying to figure out what does it mean, what am I going to spend, and what ultimately am I going for as far as the claim is concerned. And then revisiting that throughout the proceeding to see whether what you've spent and doing a cost-benefit analysis throughout the proceeding at each stage will be a sensible way forward.
Yeah, making sure it's commercially viable at the end of the day.
Yeah, that's right. Yeah, exactly right. So costs can quickly put a matter from being a commercial matter to an uncommercial matter. And while principle is important at the outset and parties sort of think about why am I doing this and it's all about principle, quickly those considerations sort of change to commercial ones. And then it's at that stage that they realise that they've spent quite a bit of money on costs. So thinking about what can I get back in terms of costs is a really useful conversation to have with your lawyer.
Yeah. Well, thanks for that, Matt. I hope everybody's learnt a little bit more about costs and litigation, and stay tuned for the next vlog. Thank you.